All right. Hello and welcome to the 22nd Annual Harvard Negotiation and Law Review Symposium. Each of us is coming from a different place today. Some of us as far as San Francisco, some of us as far as the HARC. And each of us has come today with a unique set of experiences. Our common purpose is to reflect on the intersection of alternative dispute resolution and activism. The relationship between activism and the field of alternative dispute resolution, or ADR, is not a new one. In many ways, ADR was born out of a movement to resolve disputes through grassroots, community-level approaches. Moreover, it has long been the case that the kinds of people who tend to find meaning and purpose in ADR, whether as practitioners, scholars, or educators, tend to have a strong social justice streak in them. Many would even say that their ADR work is their activism. What makes today's symposium new and significant is the push to explore how the field of ADR can learn from activists and vice versa. As activist movements have grown over the last few years, so has the curiosity grown within dispute resolution communities about activist approaches and possible opportunities for cross-pollination. Similarly, ADR practitioners are faced with really hard questions when they are involved in negotiating disputes that have social dimensions beyond the isolated dispute itself. What does a mediator's neutrality mean in a dispute that involves stark power differentials? Is one question that we'll be asking today. I want to take this opportunity to express an enormous amount of appreciation for everyone who's been involved in organizing this event. Thanks to our sponsors, the Program on Negotiation at Harvard Law School, Triad Consulting Group, Black Law Students Association, the Dean of Students, and the Harvard Negotiation and Mediation Clinical Program. Thanks to the folks behind the scenes, Restaurant Associates, the Copy Center, Facilities, and HLS Communications Office. The student leaders who've been involved from the very beginning, some of whom, Yumi Kim and Maddie Lupino, who you will see and hear from throughout the event, and some of whom, Lisa Dicker, Sydney Montgomery, Amrita, who you will see kind of running around and organizing. A special thank you to Rachel Viscomi, who will be moderating our second panel this afternoon and who provided support throughout the planning process. And also a special thank you to Bob Bordone, who provided guidance and wisdom from the very beginning. He will also be moderating the first panel and conversation with DeRay McKesson. And finally, each one of our guest speakers for the day, Grande Lum, Lauren Abramson, Jim Tull, Saad Achan, Susan Potsuba, DeRay McKesson, John Hansen, Deanna Parrish, and Melissa Bartholomew. Their bios are in the booklets that you all have, and you can feel free to read through those when you have a minute. So the afternoon is full, and we hope you will stay for all of it. I'll refrain from walking through the whole schedule because it's in your booklet, and I'll just let you kind of peruse that. And now I am very excited to introduce our keynote speaker, the Honorable Grande Lum. Grande is the director of the Divided Community Project at Ohio State University's Moritz College of Law. The JAMS Foundation provided crucial startup funding for the Divided Community Project, and the project is an exemplar in the field and a unique resource for addressing civil unrest. He is also a lecturer and research fellow at Stanford Law School's Gold Center for Conflict Resolution, the founder and a senior advisor at Accordance, Inc., and a senior advisor for Nextdoor. Previously, Grande directed the Community Relations Service at the United States Department of Justice and was unanimously confirmed for that position by the Senate. Grande spoke on the Harvard Law School campus almost exactly 3 years ago to a room of captivated negotiation workshop students. I was one of them. And brings exceptional clarity as someone who is immersed in both the theory and practice of ADR. Grande also received his JD from Harvard Law School. And please join me in welcoming Grande Lum. I'm going to turn this off now.
So I'll say good afternoon, everyone, and I want to thank Adriel for that very generous introduction. I want to also thank all the organizers as well, and all the other people Adriel thanked, the cookie makers and the Xerox people and all that as well. When when I heard that the title of this symposium was Reflections on the Intersection of Alternative Dispute Resolution and Activism, I really appreciated the word reflection. Reflection was not a word I heard much when I was at DOJ, and something I did not do enough of when I was there. So it's quite the luxury to have that opportunity to do so today. And I will say, I just feel a little more relaxed having that word up there. I think the symposium is very important and timely, given all the increase in protests we've seen, right? From Tea Party to Occupy to Black Lives Matter, and from the Women's March to Indivisible now. And I think to reflect on that intersection between activism and ADR matters tremendously, like Adriel was saying. And I think we need to be in conversation rather than in opposition. Otherwise, we might get into name-calling. By the way, what's more likely to happen is the activists might name-call. ADR practitioners would more likely actively listen and say, so you think my neutrality is a problem, or you're being part of the problem and not the solution. What we as ADR practitioners might then do is we'll go home and we'll start name-calling to our spouses and our dogs there. ADR practitioners just tend to be a little more passive-aggressive, I think. I'm not trying to offend any ADR practitioners here. I consider myself one. I now want to focus on another word in the title of the symposium. When I was asked to join you all, I was struck by the word intersection. And it would not have been the first word to come to mind for the intersection, for the relation between ADR and activism. It's such a contained and organized word. What I visualize? I visualize Professor Robert Bourdon in that Lincoln Continental right there. It looks like Matt McConaughey, but it's Bob, okay, in that car. And let's say that's ADR Street right here. And there's Activism Street right here. And, if it were as an intersection, the cars coming, they'll slow down, right? They'll see a yellow light. They'll stop 5 feet before the crosswalk. And then when the light turns green, Bob's Lincoln Continental then comes forward, right? By the way, I know it's 5 feet before the crosswalk because I just helped my 15-year-old son prepare for his driver's test permit. That's another story, which I don't want to talk about right now either. But from my experience, over the last 4 years leading CRS, it felt much more like a head-on collision between ADR and activism. And activism was like a Camaro going 100 miles per hour, and alternative dispute resolution was more like a Honda Odyssey van going 54 miles per hour. And again, ADR practitioners tend to be more conservative, drive under the speed limit, all that, right? So, I know you're all worried about the possible crash between them, but rest assured they were self-driving cars, so they were hopefully turning the opposite way when they reached the intersection. CRS went headlong into Sanford, Florida, after Trayvon Martin was killed by an individual playing a neighborhood watch role. Into Ferguson, Missouri, after Michael Brown was shot by Officer Darren Wilson, and Baltimore, Maryland, after Freddie Gray died riding in a van. These were defining moments in this country where we saw renewed activism that we really hadn't seen in decades, and we saw deep wounds reopen. At CRS, we had very gifted conciliators, and conciliators was actually their official title that they had. And they went into these communities and many other communities, I want to say, where there weren't national headlines as well, and where we made a significant contribution to change and peace. And those experiences actually really do shape my perspective on activism and ADR, which I want to speak to today, to how they fit together and how they may not fit together. I was mentioning to Professor Bob Mnookin about how, and a few other folks, how sometimes when I prepare for these things, I try to think of what do I want to say. Today was much more about, I had so much to say. Like I wrote down pages and pages, and I really was thinking about what do I want to call back to, and what do I really want to focus on here. And both at CRS, the Community Relations Service, and my current job, where I work at the Divided Community Project, as Adriel mentioned, at Ohio State, where I work with two wonderful colleagues there. Some of you may know Nancy Rogers and Josh Stolberg. We really thought through a lot about what I would call potholes or issues that exist when it comes to activism and ADR. You know, one thing that was very true when I was at DOJ, you hear it all the time, and it could be in anywhere. You heard this term in federal or state or local government, staying in your lane. Everybody heard that term, stay in your lane? It's the idea that each government agency, right, you're supposed to stick to your own narrow responsibilities and not go into another agency's turf. I am mixing metaphors here, I know that. Basically, you know, what happens when your car or agency veers into another driver's lane, right? What happens then? The other driver that you're cutting into, or the government agency, basically curses at you and threatens you, right, with road rage. There were literally hundreds or thousands of local, state, and federal employees on the ground in Ferguson, Sanford, and Baltimore when I led teams into those tragedies. And CRS had many challenges. I was mentioning earlier how, you know, I wasn't necessarily expecting this. When I took the job, I wasn't really, it wasn't at the time clear that these issues would become national headlines. And certain things I will never forget. It certainly include, there were certain meetings in Ferguson where we were trying to meet with protesters, where individuals, and many of the protest groups knew us, especially the older line ones, to be frank. But there are certainly situations where protesters said, no, we don't want you in here. You know, you're part of DOJ, you're part of the Fed. We do not want you in this room as we discuss our strategy. I also certainly remember situations where there were talk show hosts, cable TV show hosts, websites that were accusing CRS of fanning militant activism during this time as well. And I'll share a little bit more about that. And it certainly includes the perception that are we there as mollification, as there to maintain the status quo, to just get protesters to quiet down and to leave. So even when we tried to stay in our lane, there were plenty of potholes and plenty of more dangerous landmines even. What I want to do then is set the table by exploring a little more deeply the polarities and similarities between what I'll term right now conflict resolution and social justice through three key learning points. And I tried to boil down 3 points that I wanted to focus on. And one, being an active neutral is a critical role. Or alternative title, we are not playing Switzerland here. Or number 2, a conciliator is a neutral and an advocate for parties, outcomes, and approach. Or alternative title, we are not part of either a left or right-wing conspiracy here. And 3, a third party can maintain the status quo or improve the system. Or alternative Harvard negotiation title, getting to yes, but only if it's the right call here. Ultimately, what I want to explore is how those in conflict resolution can work with activists and the establishment to create a more just society and less divided communities. I very consciously use the word divided communities, not just because it's in the title of the organization I lead, but it's certainly become very relevant in this country today, that this is a main issue for us as a country in terms of division. I also want to say that I've lived this tension between social justice and conflict resolution my whole life. When I was at San Francisco's Lowell High School, I first thought about becoming a lawyer. I hope you appreciate my Farrah Fawcett haircut, my mustache, and the ruffles here. I really debated whether I wanted to show this picture or not, but I decided to do it. What I wanted to be when I was in high school was to be an Asian American Perry Mason or Thurgood Marshall. This way I got off of the high school yearbook picture quickly. When I was in high school, I remember a history teacher, Mr. Sturdivant, who took us to the Presidio, a military base in San Francisco. And there was an exhibit on the 442nd. I don't know how many of you know of it. It was the Japanese-American Army unit in World War II, the most decorated Army unit of all time. I also learned for the first time about the Korematsu case at that time. So when I went to law school, I had the idea of becoming a civil rights litigator, not a civil rights mediator. And to be honest, at that time, I really didn't know the difference between mediation and meditation. One thing I'll say is that what got me first interested in my injustice and desire for justice was I grew up a huge comic book fan. I was an Avengers nut. And in the 1970s, it was very nerdish, right, to like comics, unlike today, where it's like the biggest deal in the world. So when I came to law school in 1988, I had the idea of avenging wrongs, right? Not negotiating them. And I remember taking a course in my first year from Professor Roger Fisher and Bruce Patton. But I had this mistaken belief about the class. I thought from that class I would learn how to be a hardball negotiator. That was what I thought. I thought I would be able to get the other side to roll over with righteous arguments. I was actually a little shocked to hear what were called rules of thumb. To be hard on the people and soft on the problem, and to disagree without being disagreeable. One pro tip I would add is that they actually work with your parents and your kids. I actually have found them to work quite amazingly well. But if not for that class at Harvard Law School, I probably would not have gone into dispute resolution. And almost 25 years after that class, I used those skills in an agency, CRS, that was also nicknamed America's Peacemaker and involved in some of the biggest civil rights disputes since the 1960s. And I actually did ask protesters, mayors, and police chiefs what their interests were. Right? I did not use the acronym BATNA, but I did ask them what their walkaway was. Right? What would they do if they walked away? While I was at law school, I was actually one of the co-founders of the Harvard Law School Civil Rights Coalition when I was here in 1990 that protested a lack of law school diversity at the time. And I remember being in Pound Hall, and one of the student leaders asked, or said, "Okay, we're all willing to get arrested here, right?" And I remember thinking to myself, I'm not sure I've really thought this through. And surprisingly, when Adriel mentioned that I was confirmed by the Senate, nobody in the vetting actually asked me about my protest activities at that time. It probably helped that I did not get arrested. It probably did help. Picture here is, by the way, one of the rallies that we organized as a coalition. You might recognize the speaker, who was a classmate of mine, and some of you might recognize. I was actually standing to the right of the cameraman at the time. Anybody know what building that is that we're standing in front of? The Hark. Yeah, the Hark. By the way, walking around the Hark and Hemingway now, you don't realize how good you all have it. When I was here, it was more like a public school that hadn't gotten funding for 5 decades. It was a death. I mean, the Hemingway was a death trap at the time. It's easy to see the polarities and symbol. It's easier to see, I think, to the question I really want to focus on, the polarities rather than the similarities between ADR and activism. From an activism perspective, you can easily understand, I think, from an identity-based social justice advocate, what their suspicions are, right? When you think of what moves society forward, right? You think of legislation like the 1964 Civil Rights Act, the Voting Rights Act of 1965, the Immigration Act of 1965, Title IX in 1972. We think of legislation as what advances minority rights, and we really, of course we should. Those are incredible landmark legislation that has fundamentally changed American society. I think skeptics would also point to ADR and say, and make the criticism that you're taking something out of a crucial feature of the American legal system, right? We think of Brown v. Board of Education, Roe v. Wade. I even came across a prominent social theorist who once stated he was Mark Chesler, he was less interested, quote, he was less interested in conflict resolution than in the creation of social change and movement towards social justice. Even the term itself, alternative dispute resolution, right, it emphasizes settlement. The words themselves, compromise, maybe even efficiency over justice, and rather than determining who's right in a situation. And I get it, right? Sometimes the interest is to establish a precedent. The interest is to establish a policy, and that goes against settlement of a claim because the walkaway meets the interest so much better. And I certainly remember being here as a student, and I thought if you chose not to do anything, then you were supporting injustice at some level, right? That by not doing something, you weren't doing it. And that's the first learning point that I'd like to focus on here. And Bishop Desmond Tutu, who of course battled the South African apartheid system, once said, if you are neutral in systems of injustice, you have chosen the side of the oppressor. If an elephant has its foot on the tail of a mouse, and you say that you are neutral, the mouse will not appreciate your neutrality. When you hear that, I mean, who wants to be neutral, right? I mean, who wants Bishop Tutu criticizing you, right? And I bet Tutu's good friend, the Dalai Lama, would probably pile on too. And you can almost start to feel sorry for anyone doing ADR work. I made a choice to do conflict resolution work for my career and one thing happened here at Harvard Law School that had a profound effect on me on why conflict resolution matters. I was a teaching fellow for the Harvard Negotiation Project, and I believe it was 1990, and Professor Bob Mnookin was a visiting professor then, right? I think when you came here as a visiting professor, and in that winter session, we had folks who were from the ANC, from the African National Congress, who were in our group, and we might have had some folks from. I think we had folks from the South African government as well. And it was as a law student, it was incredibly thrilling to be a teaching fellow here. And to be just slightly involved, right? Just tangentially involved in the South African work that was going on, that HMP was doing, that Roger certainly thought was the most important work. Roger Fisher thought was the most important work of his career. I would distinguish the way Tutu used the word neutral, by which he meant a passive bystander, choosing to do nothing, versus an active neutral, right? An active neutral helping the parties achieve its commonly desired goal, the end of the apartheid structure. And I actually do remember one of the ANC, one of the African National Congress participants supporting me when in a classroom I forget what classroom we were in. Roger in class talked about something about the protests that were going around on faculty diversity, and I nervously raised my hand and disagreed with him in a classroom session, and one of the ANC participants came up to me afterward. My experiences at DOJ, it's at the Community Relations Service. It was an ADR organization, very clearly. It was created to work with activists toward a progressive goal, and it was the implementation of the 1964 Civil Rights Act. To be clear, ADR wasn't even the name of the field yet, I think, in 1964. And those people who joined CRS were pioneers in the field of community mediation. Many of them became academics, James Lowy, Wallace Warfield, Dick Salem, and others as well. CRS was created by Title 10 of the 1964 Civil Rights Act. And the immediate focus was on the desegregation of public accommodations, the hotels, the restaurants. The fear was, at that time, and it's hard to maybe imagine it today, was that there would be massive resistance, that there would be all these hotels and restaurants in the South, public accommodations that would refuse, and that you could not litigate your way out of those things, that it would be helpful to have mediators and conciliators do that. And it's often an undertold story that it was actually relatively peaceful, that many of them, after that July date in 1964, when the Civil Rights Act was signed into law by LBJ, that many of them did do so peacefully with the help of CRS folks. When CRS did its work in Sanford, Florida, following the Trayvon Martin shooting, the third-party role was crucial in both keeping the peace and, as importantly, facilitating voices that demanded to be heard. We worked with protesters, with faith leaders, law enforcement, and government officials. One important piece of the work, and it was just made into a video with a lot of Sanford folks, you can see it on the CRS website, is that it was working with local faith leaders and moving them into a key role of rumor control to deal with and prevent the fake news from going through the community. 4 representatives of both predominantly African-American and white congregations, they actually sat in the front row in the courtroom each and every day in the Zimmerman trial. The CRS conciliators who did the work were not there to prevent civil unrest, but to make sure the protesters and the officials stayed safe during the unrest, that it actually stayed civil. City officials actually went out of their way to drive protesters to the spot, to make sure that there were good accommodations. There was a lot of civil protesting there, but they were actually quite proud there was not a single arrest in Sanford. My current work at the Divided Community Project, we try to bring that work from Sanford to communities and in a prevention manner to communities throughout the country. We're working right now on a pilot project in Columbus, Ohio, and San Mateo, California. We're also in the process of creating a social media report for divided communities, focusing on how leaders need to understand the challenges of social media and how to use it to transform polarization into collaboration. I actually do believe a lot of the promise of ADR can be fulfilled by ODR, or online dispute resolution. Even though I will say I cringe pretty much every time I see my son and daughter with their smartphones, with their friends, so I'm mixed feelings about it. We certainly know technology drives much of the Black Lives Matter social movement, for example, through the high-def recording devices, Twitter, Facebook, and shining a light on what was previously unseen by society as a whole. I'm surprised Yahoo is still there. It may not, it's still relevant. But we also know, I also want to mention that solutions for law enforcement, community relations, which I spent a lot of time on in the last 4 years, they're technology-based, right? Body cams, dash cams. But we also know people, policies, and training are required to make lasting change. Let's not forget it was 3 young African-American women who created and launched hashtag Black Lives Matter right after the Zimmerman verdict. Patrisse Cullors, Alicia Garza, and Opal Tometi. It was mentioned, Adriel mentioned that I did work with Nextdoor. It's a social media company in micro and the neighborhood level, some of you may be aware of. It's where people find their lost dogs and get to know their neighbors. Some of you may be aware they had a racial profiling issue, right? Because if it's in thousands of neighborhoods, people are reporting suspicious behavior. One primary reason they use it is for that. And there was an activist group in Oakland and in other cities throughout the country. And I was, Nextdoor hired me to work with the activists, work with the designers. And it was pretty astounding to see that you could change a platform and instantly change the way thousands of people then report the behavior, that you could actually educate people and require people at some level to not racially profile when they fill in the form or choose not to fill in a form. It's amazing the power, right, that a few companies really have on behavior. And it's a frontier, I think, for those of us in ADR. I think we have a chance to lead here or get left behind. Which brings me to my second point. A conciliator is neutral and an advocate for parties, outcome, and approach, or alternative title. We are not part of a left-wing or right-wing conspiracy here. I want to lay down a little bit of theory here, and I'm not trying to steal from the first panel's theory thunder, Bob, so please don't worry about that. James Lowy, who I mentioned earlier, he was a CRSer from 1965 to 1969, probably, certainly considered by many the finest CRS conciliator of all time. He mediated during the march from Selma to Montgomery. Martin Luther King once said that the only part of the federal government he trusted was CRS, and was primarily because of this guy. James Lowy was a Harvard sociology graduate student who worked with the Southern Christian Leadership Conference, did his research there, and after that he joined CRS. He was actually in a hotel room at the Lorraine Hotel on the fateful night King was shot, was the first person to try to revive King, and actually went to the place where King was going to speak that night to implore the crowd to stay peaceful. Lowy is actually interesting, I think, because he was a lifelong advocate of social justice and the use of conflict resolution to achieve it. And he was interestingly assertive that an intervener was not neutral. He consciously used the word intervener rather than mediator because mediator conveyed more of a formalized role. I actually think Lowy's social conflict roles in community multi-party situation and Bill Urey's third side, which differentiates between third-party roles of preventing, resolving, and containing, they're highly complementary. And Lowy stated that, he stated that no intervener is truly neutral because they advocate for parties or for an outcome or for a particular kind of process. And here's where I really want to be frank. I mean, I do not think at all, especially given my past experience, we can ever run away from the word neutral. In Ferguson, like I mentioned earlier, there were times when we were perceived as, oh, you're with the federal government. We don't trust you, right? And I think, by the way, when they were kicked out, that made a lot of sense. They were uncomfortable in the moment. And let's face it, most people don't like being kicked out of meetings, right? Unless you're a protester, perhaps, with a mission. Maybe if you are Texas Senator Ted Cruz or you are Michael Moore. I'm trying to be fair and balanced about this. here's what I'd say. One thing that was true in Ferguson was that once, and I had a conciliation team that was one guy specifically who lived in Kansas City, spent a year living in Ferguson. So again, these people sacrificed a great deal, or away from their families for long periods of time doing this work. Derek Deans did an amazing job getting to know many of the protesters. They came to trust him over time. And that's an interesting thing, worth noting, what I certainly saw in my 4 years there. When you had trust, when you had credibility, when you had track record, that made it much, much, much easier to engage a conciliator in these high tension situations like that. I mentioned how the activists, when they don't know you, they won't trust you. What I think was an interesting development that I had never dealt with in highly politicized, politically charged environments were things like social media, like Breitbart.com, radio talk show hosts like Rush Limbaugh, cable TV hosts like Sean Hannity, especially during the Trayvon Martin situation, blamed CRS for working to increase the activism. A couple of things I note on this one. I was quite surprised to see my name in front of the Attorney General, Eric Holder's name. I never knew I was a bigger threat to society than Holder. And secondly, I didn't realize I was this powerful, that I was using CNN again, that we were somehow plotting our control of the world here. This is the first time I've ever talked about this publicly, because one, I don't want to give them any more airtime, fundamentally, right? When you're doing the work, you just do the work. You put your head down and deal with it. But another reason I'm sharing it, because 3 weeks ago, the Heritage Foundation, a conservative think tank, produced their proposed 2017 budget, and it proposes the elimination of CRS. And it's mostly because of all this stuff. And there's a lot worse things. I'm not telling you to look at the internet but there are a lot worse things said about us on the internet. So I would hope James Lowy would understand, my embrace of neutral. It's, when you're a third party in a highly charged situation with politics, of course, you just cannot favor one party over the other in your actions. And it's a word, the word is optics, right? It's not that you just don't do stupid things. You can't look like you're doing stupid things. And I'll be honest, because of things like this, it kept us from doing a lot of the mediation that we might have done otherwise. Because if you're in a room and somebody says something, then you're accused of something. So, for example, that first one says, we were trying to get the police chief to leave. That somehow DOJ would be blamed for trying to remove a police chief, for example. So, and I had worked as a mediator in a private situation, nonprofit, as an academic. It was different. It was different here. I do remember, playing a specific situation where I played along with the CRS team, played a communications and shuttle diplomacy role between a mayor and a group protesting against law enforcement for the treatment of African American and Latino citizens, and they were occupying downtown streets. We were very clear. We had no decision-making ability. We pushed for the parties to be in the same room, but they had such a bad relationship, they refused to be even in the same room together. I would say even in a very limited role in that situation, we were at least trusted by both sides. That ultimately, the city decided to remove the protesters. But I still think we made a difference. We helped convey messages. We helped people from getting hurt. So what were we mediating, right? It wasn't possible, practical, to get a substantive agreement. It was about, should there be heaters brought in? Where will protesters not be arrested? What happens if a police officer mistreats a protester? Trying to create what we called rules of engagement between protesters and police. In another situation, I want to give you just one other situation. It involved a state house where a group of protesters occupied it. We helped set up a meeting between the governor's staff and the protesters. And they had been occupying this for a couple of dozen days, and it made a difference, right? And we actually were able to help with some of the substantive interests. The protesters wanted to present to the state legislature their concerns, their hatred of the Stand Your Ground law in that case. So I want to bring up one ethical dilemma, and I want to move off the slide actually too. One ethical dilemma that came out of both of those situations that I just mentioned and many others is that, are we being neutral if we're spending more time with the protesters, which we sometimes are? And are we therefore no longer neutral? And that's for a variety of reasons. There are often a lot of different protest groups, and when we're engaged, we're trying to facilitate sometimes conversations among them. The protesters changed over time. This was very, very true in Ferguson. And I remember speaking to a police chief, and I asked him, would he have a problem if we spent more time with the protesters? And he said, no. That's what I would expect CRS for you all to do here. My Ohio State colleague, Josh Stolberg, had a very well-known debate, at least within the ADR academic world, which is not that big, but you know, about mediator neutrality, right? About whether a mediator is accountable for the outcome here. And without going deeply into it, I mean, I'm sure the first panel can go more deeply into it. My experience is that, practically speaking, the parties do look to, when we conciliated, they did look for both our process expertise and our substantive expertise, right? It wasn't that we were purely facilitative, processy people. That wasn't what they were looking for or expecting from us, per se. And you know, my pro tip here is what actually Bernie Mayer, I think, talks about in his response in the Marquette Law Review article about it is, I think this is true for any mediator, but it's certainly true for us, is the more self-awareness you have makes a huge difference, right? The more transparency you have about what you're doing. I think there's a big difference between saying, hey, I think we're going to spend more time with the protesters than the police. Is that okay with everybody? Versus just doing it and not explaining it or somehow being deceptive about it. The social conflict roles that Lau defined for community multi-party conflicts, I think this is interesting. He actually, in his theorizing, again, he did this after he worked at CRS, was that there are these roles that people play. One was there's an activist role. Secondly, that there's an advocate role, including lawyers. 3, that there are mediators involved who advocate for a type of process. Researchers, which included journalists, and enforcers. And this would include, number 5 was enforcers. That would include judges, DOJ. I think the perspective, I think, helps clarify the role Conciliator and puts a useful context that activists, that I think can help activists as well. And I remember speaking to the person who runs the Stanford Clinic for Public Interest Lawyering and said, it really does help, if you're an advocate, to have somebody who's there playing a facilitative role. And that, so that they don't have to play, that they can separate their roles out a bit, that there's a benefit to that. CRS was likely the very first federal group to learn about the Michael Brown shooting on August 10th, 2014, because within minutes of the shooting, we were informed, we got a call from a civil rights group. 2, we were likely the first federal group to deploy to Ferguson, and 3, we were the first federal group to speak to a broad range of protesters. How this paid off is when Attorney General Eric Holder, he's personally told me, what was arguably the most difficult decision of his tenure was whether or not to come to Ferguson like within 10 days of the shooting. One of our assets at CRS was that we were a credible convener of diametrically opposed parties. And we did it on August 18th, actually just 8 days after the shooting. We organized a town hall between Ferguson residents and the Attorney General. I facilitated that in that day. We also, on that day, organized meetings between the Attorney General, staff, and faith leaders, youth groups as well. And on that night, and I was there, certainly on that night in Ferguson, it did become calmer. I mean, the fear was by the White House and by DOJ was that what if it got worse? What if Eric Holder had come to? That would be horrible, right? A horrible outcome for everyone. And here's my last learning point, and I see that we only have a few more, 5 more minutes in time, so I want to. Clearly, I didn't cut down as much as I should have on my talk here. But here's the last point I have. That you can help maintain the status quo, or you can improve the system, or alternative Harvard negotiation title, getting to yes, but only if it's the right call. I think we have a bias for a narrative that has a shining moment of change, right? In the movie Selma, we see the confrontation on the Pettus Bridge, the signing of the 1964 Civil Rights Act. We want a singular moment that changes everything. Change is often more incremental, right? For the African-American fight for civil rights, we go back to abolition, to Reconstruction, to desegregation, to mass incarceration today. It's true for the gay rights movement, right? We can think of Stonewall or Bergefell, the Supreme Court decision upholding gay marriage equality. But there are many other smaller incremental steps, including taking out homosexuality from DSM-3 as a mental disorder. I make the argument that in any nonviolent campaign, they're basically, I'll go back to a quote that Martin Luther King had in his letter from a Birmingham jail. He wrote, in any nonviolent campaign, there are 4 basic steps. Collection of the facts to determine whether injustices are alive. That was number 1. Number 2 is negotiation. Number 3 was self-purification and direct action. 1963 Birmingham was a turning point in the civil rights, but what's often less talked about is that it was also the power of African-American economic interests at the bargaining table, and also the power of mediation. It was mediated by Burke Marshall, the Assistant Attorney General for the Civil Rights Division. He actually, at the end of that, said, "Oh, this is way too tough. It's taking away time from my litigation." So litigators actually, they don't realize how tough mediation is until they actually have to do it, I think. And so, Andrew Young came to speak at CRS's 50th anniversary. I think he's a role model. He was a reverend. He was part of this SCLC. His role, though, I'm not sure if you all know this, his primary role is as negotiator for SCLC. And he really did focus on the Birmingham Agreement and in Selma as well. So I'm going to, what I want to say here is this. If your goal is for your advocacy voice to be heard in the public sphere, then conciliation and mediation may not be the right path, and that's perfectly understandable, right? We need advocates who fight for what's right, like DeRay McKesson, who you will hear from later today, and Brittany Patnett, certainly from Campaign Zero. Here's what I'll say. If your goal is a just society and a preventative, resolving, or containing role is needed, which it often is, then conflict resolution is a noble and necessary calling. If your goal is to work with others who struggle to bend the arc of history toward justice because understanding and dialogue is needed, which it often is, then conflict resolution is a necessary and noble calling. We know there's no justice without law, and there's no law without lawyers. And since we're here today in Austin Hall with law students, I would add there would be no lawyers without law school. you know, I don't say there are no just laws without activism. You know, a sign of a mature and wise society is when an individual resorts to an adversarial legal system, right? Rather than mob violence, rather than eye for an eye vengeance. Conflict resolution, I think, does the same, right? It leavens as well through rules of engagement, like I mentioned, helping parties reach just agreements, and certainly coming to agreements when without litigation when it's appropriate. And because of schools like Harvard, Ohio State, and Stanford, I think it's an important service, right, to train folks in both advocacy and ADR, because those tools can be then used effectively together. And I do want to end with one quote from the Dalai Lama, who I mentioned earlier. I think Bishop Tutu and the Dalai Lama would agree that a neutral can make a difference. And here's what the Dalai Lama said: your friend, your enemy, your neutral are all equal. Genuine compassion is unbiased. I think when any of us can help individuals operate as their best selves, real progress can be made through litigation, through legislation, and negotiation. You know, all of us can bring a genuine compassion forward in meeting the shared goal in a more just society in a fast-moving times. Thank you very much.
Thank you so much. Thank you so much, Grant. We're going to take a break right now. We're going to start at 1:15 for the next panel, so feel free to use the restroom. I think we have drinks outside. So if you could please join me in thanking Grant again.